Welcome to Do It for the Case Law for Wednesday, July 29th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today, we are covering 45 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 15 criminal justice cases today across 7 circuits. The disposition mix includes 10 affirmances, 3 dismissals, and 1 split outcome where a sentence was vacated and remanded. I'll start with the 6th Circuit's split decision before moving through the rest of the docket. In the 6th Circuit, the court affirmed the convictions of Chanel Logan and Kari Smith but vacated Saruba Smith's sentence and remanded for resentencing. The court rejected Logan's challenges to her 360-month sentence, holding that the district court properly applied a 2-level drug premises enhancement under USSG Section 2D1.1b12 based on manufacturing equipment and large drug quantities found in her apartment. The court also upheld Kari Smith's conviction for using a communication facility to facilitate a drug offense, finding sufficient evidence of his knowing participation. However, regarding Saruba Smith, the court held that while sufficient evidence supported her conviction under federal statute for using a phone to facilitate a transaction, there was an issue requiring resentencing. Also in the 6th Circuit, the court affirmed Scott Michael Nelson's conviction for possession of illegal images, holding that he failed to preserve his sufficiency claim because he did not renew his motion for judgment of acquittal. The court found sufficient circumstantial evidence, including Nelson's admission of phone ownership and the sequential naming of files. Separately, the 6th Circuit affirmed the denial of Jarvis Claiborne's motion to suppress post-Miranda statements obtained after an initial unwarranted session. Applying the Missouri v. Siebert test, the court held that 3 hours elapsed between interrogations conducted by different officers at a new location, giving Claiborne a genuine choice to remain silent. Moving to the 7th Circuit, the court affirmed Mark Randall's conviction, rejecting his motions to suppress evidence and disclose a confidential source. The court held that the warrantless search of Randall's vehicle was lawful under the automobile exception due to probable cause from a controlled buy, and the subsequent traffic stop was justified by reasonable suspicion. In the 8th Circuit, the court affirmed Lionel Coffin's 262-month sentence for drug offenses, rejecting claims of substantive unreasonability after finding the district court properly considered statutory factors. The court also granted appointed counsel permission to withdraw. Additionally, the 8th Circuit affirmed Isaiah Thomas's 105-month prison sentence for a firearm offense, holding that any potential procedural error in guidelines calculation was harmless because the district court would have imposed the same sentence based on aggravating factors. Turning to the 9th Circuit, the court affirmed Darnecco Yates's sentence for possessing a firearm as a felon. The court held that the government acted within its discretion under the PROTECT Act to decline an additional acceptance of responsibility reduction due to trial preparation costs, and the district court properly applied a 4-level enhancement for possessing the firearm in connection with child endangerment. In the 10th Circuit, the court affirmed the dismissal of Chantel Robinson's civil complaint with prejudice as a sanction for sanctionable conduct. The court found clear and convincing evidence that Robinson submitted fabricated evidence, cited hallucinated legal authority, and sent threats justifying dismissal under the 5-factor test from Aaron v. Reynolds. In the 11th Circuit, the court affirmed the convictions and sentences of Washington Francisco Mero, Juan Carlos Marin, and Anthony Brian Mero for drug trafficking under the Maritime Drug Law Enforcement Act. The court held that the EEZ constitutes part of the high seas under the Felonies Clause, and that the statute's definition of a vessel without nationality is constitutional. Finally, in the 5th Circuit, the court dismissed 3 appeals. In 2 cases involving Darwin Ayala Ochoa and Marcus Allen Harleston, the court granted counsel's motions to withdraw under Anders v. California, finding no non-frivolous issues. In the 3rd case involving Munson P. Hunter III, the court dismissed the appeal, enforcing a plea agreement waiver of his right to appeal a supervised release condition requiring mental health medication, applying the newly announced miscarriage of justice standard and finding no such error. Back to you, David.
Thanks, James. Aisha has 4 civil rights opinions from the 11th, 5th, 6th, and 7th Circuits.
Thanks, David. 4 civil rights opinions today, 1 dismissal and 3 affirmances. We start with the 11th Circuit's dismissal of Pamela Denise Colbert versus Central Georgia Technical College. The court dismissed the appeal sua sponte for lack of jurisdiction because the underlying order denying the plaintiff's motion for appointment of counsel was not a final decision. The court held that the order did not dispose of any claims and therefore failed to meet the finality requirement of federal statute. Additionally, the court determined the order was not immediately appealable under the collateral order doctrine because it is effectively reviewable on appeal from a final judgment. Consequently, all pending motions were denied as moot. Moving to the 5th Circuit, John Hurt versus Brandon Garcia and others. The Fifth Circuit affirmed the district court's dismissal of John Hurt's employment discrimination and retaliation claims with prejudice. The court held that the second amended complaint filed by Hurt had no legal effect because it failed to comply with Federal Rule of Civil Procedure 15AA and exceeded the scope of the magistrate judge's repleading order, which only required repleading to satisfy heightened pleading standards under Rule 9. Consequently, the original petition remained the operative pleading. Regarding the denial of leave to amend, the court applied the abuse of discretion standard and found the district court did not err in determining that amendment would be futile. The underlying claims failed because federal statutes like the Age Discrimination in Employment Act, the Americans with Disabilities Act, Title VII of the Civil Rights Act, and the Texas Labor Code do not provide for individual liability against co-workers or supervisors. In the Sixth Circuit, Tammy W. Russell v. the United States Department of the Treasury was remanded to the district court to determine whether a deferred resignation program agreement extinguished her claims and rendered the case moot. The court applied the Article III mootness doctrine, which requires a live case or controversy, noting that a settlement agreement can deprive a court of jurisdiction if it completely eradicates the effects of the alleged violation. However, because the parties disputed material facts regarding the validity of the release provision in the DRPA, specifically whether Russell entered the agreement knowingly and voluntarily given her alleged anxiety and PTSD, the appellate court could not resolve the jurisdictional issue itself. Consequently, the district court was tasked with making necessary factual findings to decide the mootness question. Finally, in the Seventh Circuit, Robert R. Richardson v. Northwestern Memorial Healthcare and Central DuPage Physician Group, the Seventh Circuit affirmed the district court's grant of summary judgment in favor of the defendants in an age discrimination lawsuit brought by Dr. Richardson under the Age Discrimination in Employment Act. The court held that Dr. Richardson failed to produce sufficient evidence to create a genuine dispute of material fact regarding whether his age was the but-for cause of his termination, as required by Gross v. FBL Financial Services. The court applied the standard that an ADEA plaintiff must prove age played a determinative role in the employer's decision-making process. While acknowledging that RMG managers made comments suggesting Dr. Richardson's age and health risks were factors in keeping him on remote work during the pandemic, the court found these statements did not connect to the subsequent termination decision. Back to you, David.
Thanks, Aisha. Michael is next with the constitutional and habeas developments.
Thanks, David. 5 cases in the block today. The 11th Circuit reversed in part and remanded 1 case, affirmed 2, while the 5th Circuit denied a motion and transferred a case back to district court, and the 6th and 7th Circuits each affirmed 1 decision. Starting in the 11th Circuit, the court addressed African People's Education and Defense Fund against Pinellas County. The appellate court reversed the dismissal of the organization's First Amendment retaliation claim, holding that as a grant applicant, APDF receives full constitutional protection rather than the limited rights afforded to government employees. The court found sufficient evidence that the county revoked a prior grant and denied a second one in response to the group's expressive association with the Uhuru movement. The court also reversed the dismissal of an equal protection claim, ruling that a corporate entity can assert race discrimination claims under the 14th Amendment when it alleges injury caused by discriminatory animus directed at its members or associates. Moving on to habeas, the 11th Circuit affirmed the denial of relief for Josiah Anthony Hadley. The court upheld the state court's determination that Hadley was not in custody during 2 police interviews in October of 2014, finding no unreasonable application of clearly established federal law regarding Miranda rights under Section 2254 of Title 28. In the 5th Circuit, the court denied a motion for authorization to file a successive Section 2241 petition. The court vacated the district court's transfer order, holding that the gatekeeping provisions requiring appellate authorization for successive petitions apply only to habeas actions brought under Section 2254 and do not govern Section 2241 proceedings. Consequently, the district court lacked authority to require such authorization and the case was transferred back for further proceedings. Over in the 6th Circuit, the court affirmed the amended criminal judgment against Michael Benanti following his successful habeas petition under Section 2255 of Title 28. The court rejected Benanti's challenges to his armed career criminal classification and a ransom demand enhancement, finding any error regarding the career strike classification harmless because removing it would not have altered his sentencing exposure given the recommended life imprisonment under the sentencing guidelines. Finally, in the 7th Circuit, the court affirmed the denial of time credits for Jeffrey Jones under the First Step Act. The court held that there is no statutory ambiguity preventing the exclusion of prisoners convicted under specific fentanyl quantity thresholds from receiving credits regardless of whether they acted as organizers or supervisors in those offenses. Back to you, David.
Thanks, Michael. Maria is next with business and civil appeals from across the circuits.
Thanks, David. 10 cases today in business and civil law. The 11th Circuit vacated one, the 3rd Circuit reversed one, the 9th Circuit remanded one and reversed one, and the Federal Circuit dismissed one. The remaining 6 were affirmed. Starting with the 11th Circuit, the court vacated and remanded the Town of Pine Hill against 3M and Dike in America. The district court had remanded a state law nuisance and trespass case to Alabama State Court, but the appellate court held that 3M sufficiently alleged jurisdiction under the federal officer removal statute. Applying the Caver test, the court found that 3M acted under a federal officer by manufacturing aqueous film-forming foam pursuant to detailed military specifications, that the conduct related to that federal authority, and that a colorable federal defense existed. Moving to the 3rd Circuit, the court reversed and remanded Karen Cornish Adebisi and others against Caesars Entertainment and various casino operators. The plaintiffs had alleged a hub-and-spoke price-fixing scheme in violation of Section 1 of the Sherman Antitrust Act, claiming that casino hotel defendants used Send-In AI-powered dynamic pricing software as a central hub to exchange non-public real-time pricing data. The court found that the complaint sufficiently pleaded parallel conduct and plus factors such as synchronous rate increases despite declining occupancy, thereby surviving dismissal under Twombly and Iqbal. In the 9th Circuit, the court remanded the forfeiture proceeding involving $204,700 in U.S. currency.
Following the en banc decision in Patel, the court granted rehearing and directed that claimant Lisa Henry be given the opportunity to provide more complete responses to Rule G interrogatories before the district court proceeds on the sufficiency of her amended responses. Also in the 9th Circuit, the court reversed and remanded Serenity Investments against Sun Hung Kai Strategic Capital. The court held that under California law, conversion is a strict liability tort for which equitable indemnity is available against negligent joint tortfeasors. Because conversion lacks the social condemnation of intentional torts like fraud, comparative fault principles permit apportionment of liability, requiring further proceedings on this issue. In the Federal Circuit, the court dismissed the appeal in Trove Brands against Camelback Products pursuant to Federal Rule of Appellate Procedure 42B upon agreement by the parties, with each side bearing its own costs. Turning to the Fifth Circuit, the court affirmed a $40 million fraud verdict against Mark Siffin. The trustee for the MTE Litigation Trust challenged the award, but the court held that the economic loss rule did not bar the claim and rejected Siffin remaining arguments regarding summary judgment, evidence admission, and post-judgment motions. The Fifth Circuit also affirmed the dismissal of Gracie Faye Harris Finley's suit challenging vehicle repossession. The court held that the plaintiff waived any challenge to the validity of the arbitration agreement in her purchase agreement by failing to address it on appeal, despite admitting she signed the document containing a valid arbitration clause.
In the Sixth Circuit, the court affirmed the judgment for Bonfiglioli USA against Midwest Engineered Components. Applying Kentucky choice of law rules under Section 1888 of the Second Restatement of Conflicts, the court held that Kentucky had the most significant relationship to the dispute and that Minnesota anti-waiver provision did not preempt the analysis. The court further found that Bonfiglioli reasonably relied on Midwest Engineered Components' misrepresentation of its intent to be bound by the contract choice of law clause. Finally, in the Seventh Circuit, the court affirmed summary judgment for John Kutrubis and Betty Stokes against Eugenia Camberos regarding life insurance proceeds. Under Illinois law, substantial compliance with policy procedures is sufficient to change a beneficiary. The court found that Lambros Kutrubis substantially complied by executing a change of beneficiary letter before witnesses and directing its mailing prior to his death, despite the insurer receiving it after his death. Also in the Seventh Circuit, the court affirmed summary judgment for the City of Aurora against Joliet Avionics on equal protection and breach of contract claims. The court held that a Class of 1 equal protection theory is inapplicable to government contracting disputes because they involve discretionary decision-making. On the contract claim, the court rejected the argument that federal grant assurances or the city minimum wage ordinance altered the standard contractual analysis. Back to you, David.
Thanks, Maria. Let's turn to Raj for immigration and government.
Thanks, David. 11 cases today across 6 circuits. The 9th Circuit vacated 1 and affirmed 2. The 4th Circuit denied 1. The 10th Circuit dismissed 1. And the Federal Circuit dismissed 4. In the 1st Circuit, 2 cases were reversed and remanded. Starting in the 1st Circuit, African Communities Together versus Mullen involved South Sudan's temporary protected status. The court reversed a district court order postponing the termination of that status. Relying on the Supreme Court's decision in Mullen versus Doe, the 1st Circuit held that the TPS statute's judicial review bar applies to all non-constitutional claims challenging the Secretary of Homeland Security's determination regarding the termination of a TPS designation. Because the lower court's postponement order was based solely on such non-constitutional claims, it lacked jurisdiction and could not stand. The matter is remanded for further proceedings consistent with Mullen. In a companion case, African Communities Together versus Mullen involving Ethiopia's temporary protected status, the 1st Circuit applied the same reasoning. The court reversed the district court's order postponing the termination of TPS for Ethiopia, holding that the lower court lacked jurisdiction to issue the postponement based on non-constitutional claims barred by the statute. Moving to the 10th Circuit, Yang versus Blanche involved a petition for review of the Board of Immigration Appeals' denial of a motion to reopen removal proceedings. The 10th Circuit denied in part and dismissed in part. The court held that the BIA did not abuse its discretion in rejecting equitable tolling of the 90-day deadline because Yang failed to demonstrate due diligence, citing gaps in activity and strategic delays between 2017 and 2025. The court also dismissed the portion challenging the BIA's decision not to reopen proceedings sua sponte for lack of jurisdiction. Over in the Fourth Circuit, Paramount Constitutes versus the Director of the Office of Workers' Compensation Programs involved a petition for review of an award of black lung benefits under Section 944 of Title 30 U.S. The court denied the petition, holding that substantial evidence supported the administrative law judge's factual findings and the legal conclusions were rational and consistent with applicable law. In the Ninth Circuit, Rudon versus Blanche was vacated and remanded. The court granted the petition for review, vacating the BIA's denial of deferral of removal under the Convention Against Torture. The court held that the BIA failed to provide reasoned consideration to highly probative evidence regarding Rudon's fear of future torture, specifically dismissing news articles documenting the violent criminal history of his son and a gang associate, as well as an expert report on Rudon's PTSD symptoms from an attempted murder. Under Ninth Circuit precedent, when an agency overlooks such dispositive evidence, its decision cannot stand. Also in the Ninth Circuit, Darden versus Bisignano was affirmed. The court upheld the district court's reversal and remand of the Social Security Administration's denial of disability insurance benefits. The district court found the ALJ erred by finding the claimant had transferable skills without first determining if he possessed any, and due to conflicts between medical opinions. The Ninth Circuit affirmed the remand but denied the request for reassignment to a different ALJ. In Dumit versus Bisignano, the Ninth Circuit affirmed the denial of disability insurance benefits and supplemental security income. The court found the ALJ's decision supported by substantial evidence, properly adopting a psychological consultant's opinion limiting the claimant to simple instructions while allowing detailed tasks learnable within 30 days. Finally, in the Federal Circuit, 4 cases were dismissed for failure to prosecute. Goldsmith versus the Merit Systems Protection Board, Young versus the Office of Personnel Management, Bradley versus the MSPB, and David versus the Army were all dismissed without prejudice for failing to pay docketing fees, file required discrimination statements or file other mandatory forms. Back to you, David.
Okay, that is the Daily Rundown for Wednesday, July 29th, 2026. Subscribe or follow for the next update. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction.